Very good evening, my dear friends. And I have sent lot of material to you. I hope you are going through that and then getting benefit out of it. And then I have given you the F.S. versus Harbotel case also recently. And that original text I have sent to you, original text. So that even CLA is not available, you can take best advantage of that particular case law. And my dear friends, today we are going to discuss about the qualifications of directors of a company. Qualifications means the question comes whether you should be a graduate or you should be obviously age of majority, there is no doubt over it. But at the same time, what are the other permutations and combinations in this regard? And friends, prima facie, there is no specific qualification stipulated. If you see Arbitration and Conciliation Act, there are specific qualifications stipulated for an arbitrator, for a person to be appointed as an arbitrator. But for a direct person to become a director, there are no such qualifications. But what is most important is he should not attract disqualifications. The Companies Act under section 164 deals with disqualifications of directors. That means if any of the disqualifications enumerated under section 164, this particular person cannot become a director or continue to be a director. Both the things are there. So in that event, what we have to understand is, if a person does not attract the disqualifications stated under section 164 of the Companies Act 2013, then a person is eligible to become a director. And if he is a director already, as long as he does not attract the disqualifications, he can continue to be the director of the company. This is the fundamental principle you have to understand, my dear friends. And then, what are the disqualifications here? We have seen different segments like appointment, vagera, vagera. Now we are coming on the question of the qualifications. Qualifications are director, person intending to be director, or a person who is continuing as a director should not attract any disqualifications as laid under section 164 of the Companies Act 2013. Now I will come to subsection 1 of section 164, which enumerates the disqualifications, where it is stated that a person shall not be eligible for appointment as a director of a company, shall not be eligible. That is, if a person is intending to be director, he must now not attract these disqualifications prima facie. What are they? If, number one, he is of unsound mind and stands so declared by a competent court. What is unsound mind? Already stated under the Indian Comp.Act. A person of unsound mind could be in a drunken state, and a person of unsound could be a person who is having permanent mental disorder. Lunacy is intermittent. That's why it is called idiocy. In that event, if a court of competent jurisdiction also declares a person as a person of unsound mind, then that person cannot become a director of the company. So the qualification is that he should not attract this disqualification. Let us now come to the next aspect. A person is an undischarged insolvent. What is this insolvency? Insolvency is that a person is unable to pay his debts. It is not that his debts are more than assets. His liabilities are more than assets. He is unable to pay his debts. In that event, he is supposed declared as an insolvent by a court of law. Today it is the Insolvency and Bankruptcy Code 2016 which is applicable. And in that event, if an individual is concerned, it is a DRT under the Act, in fact, stipulates the procedure. And if he is declared as insolvent, until a rateable dividend is paid by the receiver and court grants and discharges him, he is not qualified to be director of the company. So that person is called undischarged insolvent until the court of law in fact passes an appropriate order. Then friends, third phase, if the person applied to be adjudicated as an insolvent and his application is pending, Even he applies to be declared as an insolvent and the application is pending, in that event also, in that particular person is not qualified. Then most important aspect now coming to D, clause D. He has been the intending person has been convicted by a court of law for any offense, whether involving moral turpitude or otherwise. And the sentence is that in respect of this offense, moral turpitude, is an imprisonment for not less than 6 months. In that event, after the imprisonment is served, a period of 5 years should elapse from the date of expiry of the sentence. That means if he is sentenced to undergo minimum 6 months imprisonment, after this sentence is served, 5 years should elapse from the expiry of the sentence, then that particular person is eligible, otherwise he is not. If a person is working as a director and he is convicted also, same thing comes into picture. There is a provision further, provided that if a person has been convicted of any offense and sentenced in respect thereof imprisonment for a period of 7 years or more, he shall not be eligible to be appointed as a director in any company. That means 6 months or more, after 5 years he can become. But if it is 7 years or more, he will never become director. Now this is a new clause, new clause that has been incorporated in the Companies Act. Then further E, clause E says, an order disqualifying the particular intending director for appointment as a director has been passed by a court or tribunal and the order is in force. Whatever may be the reasons, whatever may be the court or tribunal, if that order is issued, then he shall not become a director. Then another important thing, payment of calls. If a person has not paid any calls in respect of any shares of the company held by him, whether alone or in jointly with others, and 6 months elapsed from the last day fixed for payment of the call, then he is not eligible to be the director of the company. Then friends, further, if a person has been convicted of any offense dealing with related party transactions, which has been enumerated under section 188 of the Companies Act. Companies Act has enumerated, please go through section 188 thereon. Then at any time during last preceding 5 years, then also that person cannot be a director of the company. In that event, you have to thoroughly read section 188, which narrates as to what are all the related transactions. Basically, they relate to sale, purchase or goods or such materials with respect to the business or contract of the company, availing, rendering of any services, leasing, and then the underwriting and related parties' appointment and office of place of profit to the company in the subsidiary. And these are all against the interest of the company, so that this particular clause, section 188, says that it is all related party transactions. And if a person is convicted under this, then he is not eligible to become a director of the company. Then further, this particular person has not complied with the provision of section 152 subsection 3, that is DIN, that is Directors Index Number, that has been not obtained. It is now a serious issue with regard to the compliances made by the directors or persons intending to be directors of the company. Then friends, there is one more important aspect. No person who is or has been a director of a company, this is the most important thing. In fact, which has not filed financial statements or annual returns for continuous period of 3 financial years, then he is disqualified, or he has failed to repay the deposits accepted by the company or pay interest thereon, or to redeem any debenture on the due date or pay interest due thereon, or pay any dividend declared, and such failure to pay or redeem continues for 1 year or more, also he is disqualified to be a director. And then such person will not be eligible to be reappointed as a director or appointed in other company for a period of 5 years from the date on which the said company fails to do. There is one more clause, is that provided that where a person is appointed as director of a company which is in default of this clause A or B, that is, person of sound mind and then undischarged insolvent, he shall not incur the disqualification for a period of 6 months from the date of his appointment. This is an exemption. However, what you have to understand is that earlier the debentures are concerned, they are not refunded after the expiry of time, interest not paid, fixed deposits collected and they were not refunded, interest not paid, then the parties used to go to consumer courts, parties used to go to, in fact, various, civil courts and then suffer. Today they can go to NCLT. And now it attracts disqualification, so that now it is a very stringent clause on the directors. This is a great development under the provisions of section 164 of the Companies Act 2013. Further, friends, it is stated that a private company by its articles provide for any disqualifications additionally also, and then any disqualifications with regard to D, E and G. D is conviction 6 months, E is the appointment of director has been disqualification passed by court or tribunal, and G is convicted under 188. If anybody is convicted, he shall continue to apply. In fact, the disqualification continue to apply even if the appeal or petition has been filed against the order and of conviction or disqualification. Earlier, if appeal is filed, normally they could have exempted. Today it is not the case, unless there is a specific stay. But the statute says even there is a stay. Statute's meaning is even there is a stay, this disqualification continues, because that is not mentioned that if stay is there, disqualification is removed. So this is a stringent clause. Slowly Indian democratic system is improving, and then corporate democracy is also functionally improving, and corporate functioning is improving, corporate governance is improving, and we are getting step by step very good provisions. So that way I appreciate. Let us have to think on one side positively and think of the negative clauses and then make out a positive approach to remove them. So in this particular case also, we have to think positively. Situation is improving and protecting the investors thereon. Then friends, with this background, the qualifications are concerned, you have to study section 164 and then write that he does not attract any of these disqualifications, then the directors are qualified. Needless to say, they are all supposed to be persons of age of majority. Indian Contract Act invariably applies. I told you time and again, those provisions will apply and then they shall apply. Then friends, let us now come to section 165, which deals with the number of directorships. No person here after commencement of the 2013 Act shall hold office as a director, including any alternate directorship in more than 20 companies. Out of the 20 companies, the maximum number of public companies are 10. For reckoning the limit of public companies in which a person can be appointed director, the directorship in private companies that are either holding or subsidiary of a public company also shall be included. This is the most important provision. Then for reckoning the limit of directorships of 20 companies, the directorship in a dormant company shall not be, of course, included. And subject to the provisions of this subsection 1, the members of a company may by a special resolution specify any lesser number of companies in which a director of company may act as director. This is another important clause. Then friends, any person holding office as a director in companies more than the limit specified immediately before the commencement of this act, that means he is already crossing the limit by the time 2013 Act came into force, and then within a period of 1 year, he has to choose not more than the specified limit, and rest he has to resign from his office and intimate the choice made by him to each of the companies and ultimately update himself. Then any resignation made in pursuance of this particular clause shall become effective immediately on the dispatch thereof to the company concerned the information, and that person shall not act as a director in more than specified companies after disposing the resignation of his office, or in fact as director or non-executive director thereof. and then after the expiry of 1 year from the commencement of this particular enactment. Then if a person accepts an appointment as a director in contravention, most important, he shall be punishable with fine. This is all liability of the directors, which shall not be less than 5,000 rupees, but which may extend to 25,000 rupees for every day, most important, after the first, during which the contravention continues. There is no upper limit. If it is 300 days, then 300 into 25,000 rupees he has to pay. It could be extended. Then friends, I will further take you to vacation of office. Appointment I have told you, qualifications and disqualifications I have told you, the number of directorships permissible I have told you. Then under section 167, the vacation of office of director, it stated that if under any, in section 164, any disqualification is attracted, he would have to vacate his office, or he absents himself from all the meetings of the board of directors held during a period of 12 months with or without seeking leave, then he would be vacating his office. He acts in contravention of the provisions of section 184 relating to entering into contract arrangements in which he is directly or indirectly interested, then also he would vacate the office. Interested means that if a person is connected with any relatives in a particular transaction of the company, he has to disclose it, failing which it amounts to non-disclosure. And then here, this particular disclosure is stated under section 184 of the Companies Act 2013. Then he becomes disqualified by an order of the tribunal or conviction thereon, which I have already told you, and then he is removed in persons of provisions of this act he could be, and then further, having been appointed as a director by virtue of his holding any office or other employment in the holding, subsidiary or associate, he ceases to hold such office or other employment. And then a private company can put additional conditions also. Further friends, another important aspect, section 168 deals with resignation. In fact, vacation, could be by resignation also. Section 168 specifically deals with resignation thereon. Then section 169 deals with removal of directors, where a company by ordinary resolution can remove a director, not being a director appointed by the tribunal, of course, under section 242. I told you, operation and mismanagement clauses. So, once tribunal appoints, only tribunal can remove. Otherwise, an ordinary resolution is enough to remove a director before the expiry of the period, but he must be given a reasonable opportunity. The rule of audi alteram partem has to be followed necessarily in the situation. And detailed other provisions are given for removal of directors. That particular procedure could be followed by you under section 169 of the Act. And then friends, the further provisions with regard to directors, left with now the duties and powers of directors. If the duties are not followed, it will lead to liability. Liability could be fine, liability could be imprisonment. If the powers are properly followed, exercised, the directors are safe. If they misuse their powers, then the liability will come into picture. So the duty is to exercise the powers granted under the various provisions of the Companies Act judiciously, religiously rather. So we are going to study three aspects in our coming sessions, starting from tomorrow. First, I will deal with duties. Then I will go to the powers. Then I will consolidate the liabilities. With this background, the particular provisions pertaining to the directors would be concluded. Then we will go to the meetings of the company, meetings of directors and meeting of shareholders. Almost we have covered 50% of the portion under Unit 4. So by 8th, probably we will be totally completing, and I will give you a lot of other material also. Keep the material intact and then study well, so that you can definitely do well in the examination point of view. So friends, with this, I think we will close the session today. I thank you very much. Good night. Bye-bye.